Good morning, everyone. Welcome to today's webinar on covenant enforcement. We have Alan Schwartzseid with Kaye Bender Rembaum with us today. I'm Courtney Buchanan from GRS Community Management. We're going to give about 2 minutes, let everybody get settled and join the webinar, and then we'll be back for some introductions. Alan will be going over the post-evaluation that you need to fill out. And we'll get started soon. So welcome, happy Tuesday. Hope everyone's doing good, and we'll be back in a moment. All right, so let's just get started. We have a few people on today. Thank you for joining today's webinar. Like I said earlier, today's webinar is being presented by Alan Schwartzseid from Kaye Bender Rembaum on covenant enforcement for HOAs and condominiums. My name is Courtney Buchanan. I am the corporate trainer for GRS Community Management located in Lake Worth, Florida. I am also a licensed community association manager and board member. So all facets of community management I deal with in my life, personal and professionally. GRS is a mid-sized management company located in Lake Worth, Florida. We serve over 250 beautiful communities throughout the state of Florida. We have communities in North Florida, South Florida, East Florida, West Florida, you name it. We service all of the state of Florida. We've been providing great, reliable service since 1989. If you would like to hear more about our management services and the technologies that we use, you can head on over to our website at grsmgt.com. You can follow us on all the social media apps, LinkedIn, Facebook, Twitter, or X, Instagram. We have all the socials updated for you there. If you want to reach out to me with any more further questions, you can reach me at my email. It's C as in Courtney, and then my last name, Buchanan, at grsmgt.com. So Alan, like I said, he is a very dynamic presenter. I've done several webinars with him. He's one of my favorites from Kaye Bender Rembaum. He does not make this boring. He keeps it very entertaining. He is a board certified specialist in condominium and plan development law. He is working out of the Orlando firm, or Winter Park, should I say, firm for Kaye Bender Rembaum. He is a firm member. So today he's going to be talking about covenant enforcement, the do's, the don'ts, that you have to be uniform. Please take note, board members, you can't give someone a violation and the other guy's doing the same thing and not give them a violation. That's very, very important. So let's also keep in mind that we will have the Q&A open. I will be answering the Q&A today as Alan's going to be presenting the materials. Just a note, I may be a community association manager and I may be a board member, but I am not an attorney. So please take my answers with a grain of salt. I know some stuff, but not everything. I will answer to the best of my ability. Some of the questions that I feel are a little bit more challenging, I may leave open. I am not ignoring you. I just rather feel comfortable. I feel more comfortable with Alan answering these questions towards the end of today's class. We will give a little bit of time to answer questions. We may not get through all of them. We apologize for that. And please, please, please keep the question on today's topic. If it has something to do with service animals or something else regarding community association management, we will not be able to answer those questions. We just want to answer questions about covenant enforcement because that's what today's webinar is about. Also, with that being said, please try to keep those questions very general. If they're too specific, we are going to tell you. Talk to your own association attorney. That's why you guys have them. So please keep them general and we'll do our best to get to everybody. And I hope you enjoy today's class. And then one more shout out for Kaye Bender Rembaum. They offer so many classes. I think there's probably another one later today on another topic. I know they have several tomorrow, several the next day, a million next week. They go to all the expos. If you want more information on where you can find these classes, go to their website, kbrlegal.com. They have the KBR calendar. It's all laid out there. It has all the links and registrations that you need. So definitely go register for more classes, get your certifications, get your credits, and you will be a better property manager or board member for it. So with that being said, I'm going to hand it over to Alan. Thank you so much for providing today's course. I really look forward to it.
All right. Thank you, Courtney. I mean, you kind of covered almost everything I wanted to say before we really get started. So thank you. That makes my life a lot easier. First of all, thanks to GRS for having us today. It's extremely helpful to be able to provide this kind of information, not only to people that already know who we are, but to others that are getting the benefit of working with us, at least for today, that might not have had the opportunity if not for GRS. So thank you for the opportunity to help you guys out a little bit today. I did want to mention, and I'm putting a link in the chat right now. That's for the evaluation after the class. So please, we want to know how we did today. GRS wants to know, we want to know. We want to know what other classes might be helpful to everyone that's here. We've got over 150 people that are attending today. I'd really like to know what you thought of today's class. It's going to ask for your contact information. It's going to provide my contact information, Courtney's contact information, a link for your certificate, which you'll want to have for credit so that if you have that board member education requirement, you can help to cover it. You'll also get a link for all the slides that we're using today, so you can download them yourself, and then links to our website and GRS's website. So again, I'm sure we'll get questions throughout. It'll all be in the Q&A, and that'll be fine. But I'm letting you know that the chat, the only content that's in there right now is going to be that link for the evaluation. That'll be how you get your certificate after the class. It'll also contain an option if you want GRS or you want our firm to reach out to you, because many people, frankly, want that Q&A but aren't comfortable asking the question in front of over 150, now 170 people. So feel welcome to fill that out if you'd like me or Courtney to contact you. I don't poach clients, but if you're not happy with your current counsel, or as surprisingly as it sounds, I know of a lot of communities in Florida that just don't have an attorney. We don't have monthly minimums. We don't require an upfront retainer. We'll pull your governing documents, get a copy of them to you, and that's the only upfront charge of working with our firm. So, if you just need an attorney that you can rely on as outside counsel when things pop up, I welcome you to reach out to me directly. My email is going to be in the slides that you'll get, and also when you fill out that evaluation, my contact information, is, like I said, as well as Courtney's, will be there for you. 30 years of being open as a law firm, 21 attorneys, 9 board certified in community association law. I'm one of them, as Courtney mentioned, and also another attorney that's board certified in construction. So anything that pops up that your community might need, we really don't do the owner's side of things. We really only work with people like those that are on this call. So again, welcome you to reach out if your association ever needs an attorney that's going to be responsive and get back to you within 1 business day, because I know that that's a problem that a lot of communities have been having. But this is not about pitching my firm. This is about giving you guys some education. So let me go ahead and I'll share my screen, and hopefully you will be able to see what you need to see. Okay, slides are up and we're good to go. Again, my email address is right here on the slides, and I think Courtney mentioned Winter Park as the city we were in. It's actually Winter Springs, just to be clear. That's okay. People that are not from Central Florida, I'm impressed you remembered the Winter Park and you got a city that actually exists. So good job. So I manage the Orlando area office of the firm. We've got offices in Palm Beach Gardens, Pompano Beach, Tampa, and Miami by appointment. So we really do practice statewide. Anything that's north of Vero Beach other than the Tampa area is usually going to be me, but you're welcome to contact our firm in general if you need any assistance. Moving into the actual materials. Welcome to the class. Congratulations, you made it. So here's what's important for everyone that's in the class to know. The association, and what we really mean by that is the board, is charged with the responsibility of uniformly, and this is what Courtney was talking about a minute ago, uniformly enforcing the governing documents, covenants, restrictions, rules, regulations, architectural criteria, policies, all the other stuff that goes into the operation of your community. If the association doesn't enforce its covenants, they may be waiving that enforcement. We'll talk about what that means later, but basically you might be giving up the right to enforce in the future without taking additional actions if you don't go ahead and enforce this stuff uniformly across the board and actually enforce it, not just send some notices and then ignore it. Now, I mentioned the board. The directors owe a fiduciary duty to do what they reasonably believe to be in the best interest of the association. I can promise you it is not in the best interest of the association to ignore violations of your covenants, rules, etc. So this is just kind of a starter slide to get you guys primed for the real information. Moving along, some of the specific covenants, some of the restrictions that the board is responsible for enforcing, you may have these in your governing documents, you may not. So you might have in an HOA architectural standards and alterations to the parcels, meaning someone's going to build something on their lot. What are you going to do about it? Do you have a process that says that they actually have to fill out an application and the board gets to decide, or the architectural committee gets to decide whether that's acceptable or not? There are limitations on how you enforce that stuff. Age restrictions that you might see in a 55 and older. We say 55 and better communities now, but those might exist too. Pet restrictions. Are you going to have a disability-related requests policy in place so that you don't screw up those requests and end up with a claim for discrimination? Restrictions on leasing and sales might be in your governing documents. If they're not in there, you don't have restrictions. Guest and occupancy restrictions, same deal. You might have parking and vehicle restrictions. That's a fun one that we'll get into later because the legislature loves to mess with HOAs. And then nuisance conduct is another one that might be in there and is like one of the most difficult things in the world to prove, because what is a nuisance is up to the individual judge or jury. And most of the time, by the way, these types of disputes are going to be in front of a judge without a jury involved. So what do we do when someone violates the covenants? The first step in enforcing that violation, you got to let the person know they did something wrong. Otherwise, how are they supposed to know to fix it? Okay, so step one, you send out a notice of the violation. Now, usually that's going to be done by management. Sometimes there's 1, 2, or 3 letters that are going to go out from management before that reaches an attorney. That should be something, in my opinion, that goes into a written policy of the association so that everyone knows within the community what to expect if they do something wrong, if they violate the rules, violate the covenants. When that voluntary compliance is not achieved within the period allotted. Now, notice those words, within the time frame that you provided. If that letter doesn't say, if you don't do X by Y date, we will do something else, all you're saying is, hey, you were wrong. Don't do that. It doesn't get you anywhere. So my recommendation, make sure that there's a time frame for curative action in that letter. And it not only says what was done wrong, but what they need to do to fix it. Now, we'll get into later, some of the statutes for HOAs actually say that that is required if you're going to go out and try and fine or suspend use rights or voting rights in an HOA. So it may become subject to mediation or formal action in court. We'll get into what that means in a little more detail later. But the bottom line is you're letting them know that there's going to be extra action taken if they don't cure the violation. If you're not saying that, then your letter is nothing more than a courtesy notice. You can call it that, but you want it to actually have more of an effect than a, hey, just letting you know, just want it to be kind and nice. No, they didn't follow the rules. You can be kind and nice in the language of the letter, but let them know there will be consequences for ignoring that letter. Now we move into fining, and I won't get deep into why I despise fining other than the fact that it doesn't cure the violation. It's a waste of time, in my opinion. And I have many communities, the board will say, oh, yeah, that's all we do, and it works just fine. Okay, but you've got 30 owners in violation and you've done nothing about it really. And you think that having that fine on the record that you're never going to try and collect, you're never going to enforce, you're never going to file a lawsuit over, and you're going to waive it the second that there is an estoppel request because someone's selling their property, you think that's enforcement. I can tell you from an attorney's perspective and practicing in this area for as long as I have, you're wasting your time. You're guaranteeing that most of those violations won't be cured. But if you want to fine as well as other enforcement mechanisms, here's how you do it right. Okay, the association under Chapter 720, which is the HOA statute, as well as the condo statute, Chapter 17, and by the way, co-ops as well under Chapter 719, can fine an owner or anyone else that's violating the governing documents or the rules. The fining rights don't have to be in the governing documents themselves, meaning you have a statutory entitlement to levy these fines. Okay, the fine can't exceed $100 per violation or $1,000 in the aggregate. What does that mean? It's $100 per day if it's cured on one day, or if it's the type of violation that happens and then it's done because, for example, it's screaming at the manager for no reason. That happened once, it's done. It's not an ongoing violation unless and until it happens again. Okay, if we're talking about parking a vehicle in a place that it's not supposed to be located and it's not moved, that's an ongoing violation. So the one-time violation is $100 for the violation. If it is ongoing, it's $1,000 in the aggregate, meaning you can have up to those 10 days totaling $1,000, unless your governing documents say that it can be more or less. Okay, so what you're going to want to do, check the governing documents, or more likely have your attorney do so to verify what you can actually charge by way of fines. Some communities have a fining schedule. I don't have a problem with that, other than the fact that it leads to selective enforcement claims or leads to uneven enforcement, even if it's not selective. That doesn't mean that it's wrong, but it just gives people one more reason to complain about their HOA. And we really don't need more reasons to complain about the HOA, let's be honest. So the better course of action, in my opinion, go forward with the enforcement process, send the letters, either do self-help or seek an injunction. But we'll get into that later. So moving forward, fine of $1,000 or more can become a lien in an HOA only. Okay, in a condo or a co-op, you are not going to be able to lien for those fines, which makes it even less worthwhile to undertake this entire exercise of levying the fine. Okay, in an HOA, if your governing documents say you can lien for fines, then you can. If they don't say so, you can't. You can't levy a fine, and this is the process of going through and frankly wasting a lot of time, in my opinion. And in case you can't tell, I'm not a huge fan of fines, but I'll try and curtail that a little bit, sorry. But a fine can't be levied unless the association, one, holds a board meeting, two, provides notice of a written notice of the violation, how to cure it, and when a committee of 3 individuals who are not members of the board, their parents, spouses, no directors or employees of the association. So this is a separate committee of 3 individuals that's going to meet and decide whether the fine should be levied. So again, that notice is going to be provided at least 14 days in advance of the meeting. It describes the violation, what to do to fix it, and it's going to say the date, location, and if it's going to be held virtually, which is now allowed in HOAs, the access information, so the phone number to call in, the Zoom link, etc. Moving on, again, the hearing needs to be held in front of a group of 3 unrelated individuals, in other words, not related to the directors, officers, or employees or managers of the association. Again, the meeting can be held electronically. Now, the important part to note, if that committee doesn't approve the fine, and that's by a majority vote, okay, so if 2 out of those 3 vote, nope, no fine, no fine, it can't be imposed. If the fine is approved by the committee, the fine's due on a date that's determined by the committee no sooner than 30 days after that meeting. So in addition to having to go through this entire procedure, which by the way, we're not done with yet, the owner then has 30 days to pay the fine. The notice of the approved fine, the due date, and how to cure the violation needs to be provided within 7 days after this hearing. Okay, so you've basically got a week to provide that notice saying, hey, the fine was approved, you have to pay it within 30 days. Until that due date expires, no attorney's fees can be charged related to the fines. Now, my opinion is that that doesn't mean you can't take separate action that you charge attorney's fees for, but you can't charge attorney's fees with respect to the fining in particular until that due date expires. This is another reason why I say don't bother with fines, just go after the enforcement, because if you're not levying fines, that time frame doesn't exist and you can charge the attorney's fees as long as your declaration provides for it, which we'll get into later, right away. If the violation is cured before the hearing or in the manner specified in the written notice before the hearing, you can't impose a fine. So now we're saying you can't have a fine if the committee says no. You can't have a fine if the violation's been cured before the hearing. Okay, so why are we doing this? I don't know. For violations that can't be cured, it's not clear under the statute what we're supposed to do. Again, those one-time violations, it's not really clear whether the statute says you can't fine for them at all, or if it's just saying that you don't get the opportunity to cure those and avoid the fine. That's one of the technical problems that a committee that includes me has brought to the legislature on behalf of the Condo Committee of the Florida Bar. In other words, we're trying to fix this technical glitch, but as of right now, the statute's not clear as to whether you can enforce these at all as to the one-time violations. If they're short term, same deal. What do we do here? The legislature has not clarified. Now, one thing that is clear is as to that 14-day notice and that meeting, the committee meeting, you have to hold the meeting, not just offer it. The legislature actually clarified that last year because there were some attorneys that were arguing you have to give the opportunity for a hearing. Now the statute is clear that you need to provide the hearing itself. So don't just sit there and send them a notice saying you can request a hearing within 14 days. That's not good enough for a fine in an HOA anymore. Moving on, notwithstanding any provision otherwise in the documents, an HOA can't fine for two new things. This is July 1st, 2024 legislation. Okay, so this wasn't in place if you took this class with me before. Leaving your garbage cans at the curb or the end of the driveway within 24 hours before or after whenever the garbage is supposed to be collected is no longer the proper subject of a fine. Now, my perspective is this is absurd because you're basically telling people they can leave their trash cans out on 3 out of 7 days. Or if you've got 2 trash collection days, 6 out of 7 days. However, from my perspective, this is the first thing that we'll talk about that might be considered unconstitutional. And here's why I say that, okay? We're going to do a little bit of analysis that you probably don't need, but that your attorney should know about. And if they don't, you might want to talk to another attorney, okay? This is called a Kaufman analysis. The case of Kaufman versus Scheer basically says, if you've got language in your declaration that adopts the Homeowners Association Act or the Condo Act as applicable, as amended from time to time, and that's the magic language. So if your governing documents say they're incorporating the statutes as amended from time to time, then any change in the statute is going to apply to your community across the board. It doesn't matter what kind of change it is, the statute will control over your governing documents, meaning this provision is going to control over your governing documents. However, if you don't have that language, which most HOAs and some condos don't, then this change to the HOA specific statutes could be seen as impairing the existing contract rights that you had. Meaning if your community is 60 years old, like some of the ones I represent, and all of a sudden the legislature is saying, yeah, I know that you've been able to enforce that for 60 years. Now we're just going to tell you, no, you don't get to do anything about that, or at least you don't get the fine for it. Well, the association's response could be, no, legislature, you don't get to impede a contract. The constitutions of Florida and the United States say that you're not allowed to do that with new legislation. And because this is a substantive issue, meaning you're changing the substance of that contract, not just the procedures the association follows, this means that this statute shouldn't be applied to the association. Now, in order to raise that argument, you really need to be prepared to take it all the way up to the Florida Supreme Court, which is the only court that's allowed to really decide constitutional issues in Florida. But that doesn't mean you can't raise the issue until someone raises a meaningful challenge. Okay, so this is an issue that you're not going to want to just rely on what some guy that you don't know that well yet, maybe on a webinar told you. You're going to want to talk to your attorney and say, hey, I was on a webinar with Alan Schwartzseid of KBR. He's board certified in this area of law, and he suggested that we talk to you about whether this is constitutional or not for our association, and what are the risks and benefits of ignoring this legislation, because in his opinion, it might not apply to us. Okay, the same thing is going to apply, although maybe a little bit less, because it's a little less egregious in my opinion, to the statute that now says leaving holiday decor or lights on a structure for longer than indicated in the governing documents is no longer the subject of a fine, unless you give notice and it's been a week after you gave the notice that they need to be taken down. Then the legislature allows the association to fine for still leaving it up. So in other words, they have a week after you provide notice. Now note that this is not a week after the timeline that's stated in the governing documents. So for example, if your governing documents say all holiday decor must be taken down within a week after the holiday, and you don't provide notice for 3 weeks, they've now got 4 weeks before the association can fine. So what you'll want to do is make sure that your manager, or if you're self-managed, you're going out and investigating and doing your little site visit and making sure that you monitor what's going on whenever that time frame would expire for people to start taking this stuff down, so that those notices can start going out right away, and you're not giving people too much extra time. You may want to give the extra time. That's up to the board. All right, we went through that. Now in a condo, like I said, you have the right to fine. Doesn't matter if it's in the documents, same dollar figures, but the process is a little less cumbersome because the legislature didn't change the process for condos in fining this year. So that board meeting 14-day notice, yep, still required, okay? And a 5-day notice that the fine is due is all that's required. But we don't have the 7 days that you need to let them know. We don't have the 30-day expiration of that notice. We don't have the no attorney's fees until the notice expires, etc. in a condo or a co-op. That only applies to HOAs. Now, a fine cannot become a lien against a unit in a condo or a co-op. It can be used for suspension of use rights and disqualification of directors as a monetary obligation that the owner or the person that we're talking about is delinquent. Okay, we'll get into that in a minute. Right now, actually. Okay, the association can suspend the right of an owner, occupants, tenants, whoever might be violating the governing documents to use portions of the common areas and common elements, common facilities, or other association property. If there is a delinquency for more than 90 days in any monetary obligation, like I said a minute ago, that includes fines. So that's really the only place that I see fines being actually useful, is when that monetary obligation becomes 90 days past due and you can suspend these use rights and voting rights. Maybe. We'll get into that in a minute. Okay, the suspension needs to be approved by the board at a duly noticed board meeting. If it's a suspension for non-payment, you don't need a separate committee meeting. If it's for violations of the governing documents that are non-monetary, that's separate, and we'll get into it in a minute. Keep in mind, that suspension is not going to apply to the portion of the common areas, common elements that they need to use whoever this person's whose rights is being suspended. And again, that's not limited to the owners. It's anyone that may use the common areas that is affiliated with that owner unless they own a separate unit. They're going to be prohibited, but they have to be allowed access to the parcel, the lot, the unit. They have to be provided utility services. And you can't impair vehicular or pedestrian ingress or egress, meaning getting in and out of the community and to the parcel or the unit itself, including the right to park. So you can't say this is a limited common element, you don't have the right to use it anymore. They have the right to use it. What you can suspend are amenities. So the pool, the gym, the clubhouse, similar things like that. Okay, moving on to voting suspensions and use right suspensions. In a condo, that suspension can't include the limited common elements only for the unit, common elements needed to access the unit, utility services, parking spaces, or elevators, meaning you can't say you can't get to your unit. That's just not allowed. In a condo, in an HOA, the dollar figure doesn't matter. It's just 90 days. In a condo, the monetary obligation, and this will apply to co-ops as well, the monetary obligation needs to be $1,000 or greater, and you need to provide proof of the obligation at least 30 days before the suspension is supposed to kick in. Okay, so it's not just you have your board meeting and you say you're done. That's what applies in an HOA. There are additional requirements here in a condo. In a condo, if you're saying that voting rights are going to be suspended, you need to do that at least 90 days before the meeting for which those voting rights are suspended. So if your election's coming up, don't look at that, 65 days before the election to determine which rights to suspend. You want to look at it at least 120 days in advance, get your notices out, and keep in mind, since you have to give the additional 30 days notice and it has to be $1,000 or more, you actually have to start this process at least 4 months before that election. So it's extremely difficult, unfortunately, to do this for a condo election or a condo member vote. But if you plan ahead properly, it's not difficult at all. Now, once that right is suspended, it applies to the entire unit or the entire lot. One question I get is, well, what happens when someone was 50 grand delinquent and they pay $40,000? That's a huge chunk. Or they go on a payment plan. Well, technically, they haven't paid in full unless the payment plan is in a written agreement that says that for this purpose, they're to be treated as paid in full, even though they're paying over time. Okay. So if you have a written agreement, that doesn't mean that the issue is fully settled. It means that you're allowing them to settle it unless they've actually complied. So until you have that 50 grand in debt, until you have that violation cured, until you have everything resolved, you don't have an obligation to remove the suspension. Okay. Now keep in mind, when it comes to suspending voting rights, that vote doesn't count for any purpose whatsoever. So you can't use it towards a quorum. It comes out completely from the equation. So if you have 100 units in a condo and 5 voting rights of units have been suspended, you now have 95 units for purposes of that meeting or those meetings. Another avenue that we don't mention here, but can be useful, if someone owes you money, instead of just suspending these rights and they have a tenant in the unit or in the lot, send a rent demand notice. It's basically a statutory form letter that your attorney can prepare for you if you don't have one. And it's going to say, hey, tenant, you have the obligation to pay your association instead of paying your landlord. And if you do that, then your landlord can't evict you for non-payment as long as you pay us. Now, if you pay nobody, we can both evict you, because that's the right that the association gets if someone ignores that rent demand notice. But that's another useful tool to get paid with minimal expense. Usually that's going to be an hour or so of attorney's fees for your attorney to prepare that form for your association. Moving forward, oh, by the way, that usually tends to work the best in areas where someone's going to throw another tenant right in there, because if you keep sending that notice, then eventually you'll get paid, because they'll keep having to find new tenants every couple months. To take effect, you do need to give written notice of the suspension. That's by mail or hand delivery to the owner and anyone else that you're suspending. Notice in an HOA needs to be given no later than 7 days after that committee meeting that we talked about earlier. It needs to say what rights were suspended, how to cure the underlying violation or make the payment, and how the violator can resolve the suspension. If voting rights are suspended, the voting interest allocated to that unit is not counted at all, which is what I said a moment ago. But again, it doesn't count towards a quorum. It doesn't count to conduct an election or approve any action whatsoever. Now, we've got some case law on the issue of voting rights suspensions. So the De Soleil case basically says no voting rights suspension is permitted in a condo, even though the statute says so. Now, again, this is condo, could apply to an HOA as well, unless the declaration was recorded after the statute was created, meaning you already had this statute in place, so everyone was on notice that this was going to be something that you had the right to do. You have the Kaufman language we discussed earlier in your declaration to adopt all the future changes to the statutes. That's that as amended from time to time language. Or the governing documents expressly authorize voting rights suspensions, which I do have some clients that have that language directly in their documents. Keep in mind, language that says you can suspend use rights does not mean you can suspend voting rights without it separately saying you can suspend voting rights. So this is the three-part, I won't call it a test, but these are the times that, and these three items were not necessarily mentioned in the case, but as a result of the De Soleil case, this is what you need to look for in order to be able to do voting rights suspensions. Okay, Covenant Enforcement Committee, the association can suspend the right to use common areas, common facilities. We talked about this. You can't suspend use of certain areas that we talked about. The suspension can't be imposed unless the violating party had an opportunity to appear before the committee on the issue. So again, same procedure, whether you're condo or HOA, you're following your fining procedure, you're just voting on a separate issue. You're voting on either fines, use right suspensions, voting suspensions, or a combination of all three. So what happens when we actually get a violation and someone ignores the demand? In an HOA, you've got a couple stages in the enforcement process. It's not mandatory to have your manager send a notice or send several notices, but it is customary. Now, if you're self-managed, it's not necessarily problematic to have the association send these notices out before it reaches the attorney stage. Usually, you'll have 1, 2, or 3 notices from the association without the attorney involved. Then it'll come to the attorney to send what I call a nastygram. It's basically a more forceful letter that's still not to the extent of we're going to sue you right now. And then if that's not complied with either, because keep in mind, a lot of times someone gets a letter from an attorney and suddenly they take it seriously. It could also be the first letter they get via certified mail and actually read instead of throwing it away, thinking it's a notice of a meeting or something like that because it's coming from management. But once all those notices expire, and again, my strong recommendation is that the association have these steps written down in a written policy that's been adopted by the board, which we prepare on a daily basis for clients of the firm. But after all that expires, you've gone through your association notices, you've sent your nastygram, they've all expired, the owners ignored you, you tried fining, it did absolutely nothing, big shocker. Now you're going to go and send what's called an offer to participate in pre-suit mediation. That letter is exactly what it sounds like. It's a statutory form. It's a fill in the blank with the owner's information, the violation information, and it's basically a letter that says, hey, you haven't done what you're supposed to do. If you don't respond to this letter within 20 days agreeing to mediate this ongoing dispute, we're going to file a lawsuit against you. Okay. If the owner doesn't respond to that letter, they don't get their fees and costs back, even if they win that resulting lawsuit. If they cure the violation within 20 days, okay, no lawsuit needed anyway. But there are certain disputes that are subject to this pre-suit mediation. Most are not. The ones that are subject to it in an HOA are listed here. The most important one is the one at the bottom for purposes of what we're talking about today, covenant enforcement. So you didn't follow the rules. That's subject to pre-suit mediation, meaning the association needs to send that offer letter before filing its lawsuit. Now, there's a reason that I like mediation and I actually am certified as a county and circuit court mediator. This is your opportunity to frankly blitz and push the owner to get this thing resolved before you have to spend the money to file a lawsuit, go get them served, etc. This is the opportunity to resolve this amicably before it gets to the point where the association's just pushing forward with litigation. So from the owner's perspective, if they're reading the letter and understanding it, they're picking a mediator out of the 5 the association selected. And hopefully that mediator is pushing you guys, both sides, towards a settlement. That's the purpose of that mediation. It's to get this thing settled and have a written agreement that says, here's what the owner's going to do. If the owner does this, everything's good. If the owner doesn't do it, hopefully your attorney is preparing that agreement in a manner that says the association gets to skip any other notices. The owner acknowledges that there was a violation and that it wasn't cured by the date of the mediation. And the association has a really streamlined process in moving forward. Now, this is also why I suggest, as a little bonus content for you guys, any settlement that you have, whether it's a payment plan, an agreement to defer, moving forward with covenant enforcement, whatever it may be, should be in a written form that's prepared by your attorney, whether that's a form that you use in 50 cases or it's prepared for that particular matter, but it should be in a form that specifies what's going to happen if they don't follow it. Because all too often I see, oh, yeah, we'll give you a 6-month payment plan. And the payment plan is an email that says you're going to pay every month, right? And the owner responds, yes, that's the payment plan. Okay, but what happens if they don't? Now you've got 6 months worth or 4 months worth of notices that you still need to send out before you can file your foreclosure lawsuit. Same here. If after you send your first letter, the owner says, I'm going to do it, it's not a problem, I just need 90 days to get it done. Okay, you sign an agreement saying you'll do it within those 90 days. You acknowledge there's a violation. You acknowledge that you're going to do it within the 90 days. And if you don't, we don't have to send the other 1 or 2 letters from management. We don't have to send the first letter from the attorney. We don't have to send the offer for pre-suit mediation. We don't have to do self-help. We're entitled to an injunction pursuant to the agreement itself. Or if we do self-help, you won't impede it, etc. We'll get into self-help in a moment. But those are the types of things that you want to see in an agreement to have it actually have some consequence. If your attorney's not preparing those agreements, and by the way, do not expect your manager to have done the unauthorized practice of law by drafting that agreement for you. Okay, that's not the manager's job, but you should be referring to your attorney to go ahead and prepare that and have some real consequences here. All right, so moving on, we talked about what is subject to pre-suit mediation. The covenant enforcement is the most important for purposes of today. There's a bunch of stuff, like I said, that's not subject to pre-suit mediation in an HOA. Okay, I won't go through it, but the biggest one is collecting assessments, fines, or other financial obligations. If someone says you can't file your foreclosure lawsuit because we didn't go to pre-suit mediation, you tell them they're an idiot, because they're absolutely misunderstanding the statute, and there's a specific statute that states that collection of assessments is not subject to pre-suit mediation. In a condo, again, covenant enforcement is also the subject of pre-suit mediation. There are different options in a condo. So, and when I say different options, I mean for the pre-suit stage, what are you going to do? There are several options that we'll get into in a minute. I think I have a slide on it that we'll talk about momentarily, but it's basically the authority of the board to require an owner to take action or not take action. That's your covenant enforcement. It's just worded differently in the condo statute. Co-op statute, same thing, by the way. There are, again, things that are not subject to dispute resolution before a lawsuit is filed. Those also include collection of assessments. That's the biggest one that I see owners misunderstanding. Moving forward, additional things not subject to pre-suit mediation. Some of these things require mandatory arbitration with the Division of Florida Condominiums, Timeshares, and Mobile Homes. They, again, are not going to be the covenant enforcement issues we mentioned earlier. Okay. The other thing, disputes between parcel or unit owners, unless the association is a party to that dispute, are not the subject of pre-suit mediation. So a lot of times someone wants the association to go after their neighbor so that they don't have to do anything about the problem. Your response to that, unless there are certain things that apply, let's see, sorry, I pushed ahead too quickly. Unless there are certain things that apply that relate to discrimination, usually the association doesn't have to get into those neighbor-on-neighbor disputes. What I mean by that is stop spending attorney's fees, stop spending your time, your money, dealing with issues that really don't involve the association at all, other than the fact that there's a violation. If you want to enforce the violation, you should. But if it's a violation that doesn't impact anyone and you'd be taking a risk as an association and enforcing it, let the neighbor take the risk and stop dealing with it. Have your attorney send a letter to both sides saying this is a neighbor-to-neighbor dispute and we're not touching it. Leave us alone. Do what you got to do. And that, again, should be something that you run by your attorney rather than having the association send that notice out saying we're not touching it, even though it is a covenant violation. So we talked briefly about the offer for pre-suit mediation. List 5 acceptable mediators. It's sent certified mail, return receipt requested, copy via regular mail. Your attorney should be sending this, which is why I'm kind of breezing through it, but I want you to understand what it is. Again, it gives you 20 days for the owner to respond, selecting a mediator and saying, I'll agree to go to mediation with one of those 5 that the association listed. If the owner agrees, you've got 90 days to mediate. Otherwise, that mediation is waived and you can move forward with the litigation, meaning the owner can't just hold this off indefinitely saying, oh, I'm not available for the next 90 days. Okay, if 90 days pass from the date that letter was issued, you're allowed to file your lawsuit. That doesn't mean I recommend you do it. Okay, a lot of times that mediation is where these things get settled. And I'd rather see you spend $1,000 on mediation than 10 grand on a lawsuit or more. Now, I'm not saying every lawsuit costs that, but it does happen. If there's no statutorily compliant response, meaning they don't respond via certified mail, return receipt requested within the 20 days they're provided from the date the letter is issued, the owner or recipient of that letter has waived their right to recover attorney's fees and costs, even if they win that resulting lawsuit. So that's why it's important to send this out, because not only are they at risk if you send it and they don't respond, but you don't get your fees and costs back if you don't send this letter. So you can still file your lawsuit. You might win, you might get your injunction, but you might spend $10, $15, $20,000 with a really recalcitrant owner that you won't recover. So bottom line, make sure that you're going through this step. Don't try and push your attorney to skip it. It's not a good idea. If you go to mediation and you don't result in a settlement, yeah, then you can file your lawsuit, no problem. Now we have the arbitration procedure here. My perspective is if you can skip arbitration, you should. The reason for that is we mentioned the division earlier. Okay, they have jurisdiction over all these arbitration matters. The government is going to appoint someone who doesn't necessarily need to be fully up to speed or board certified in this area of law and have a lot of knowledge to deal with that arbitration. That's not necessarily a problem in and of itself. Most judges don't have a lot of knowledge in this area of law either. The problem I have is that the arbitrators, there's case law that says they can decide each one of these issues completely differently from the last time they decided the exact same issue, including involving the exact same parties. They can be completely arbitrary in their decisions. So there's no guarantee, even if you're 100% right, that you win at arbitration. Then, if the arbitration's done and it's non-binding arbitration, meaning you can go one route, which is binding, meaning that decision is final, or non-binding. If it's non-binding, that means that you then have to file your lawsuit anyway to try and find out what a judge says about the issue. I would rather see the association try and get it settled at mediation, then file the lawsuit, and you're done, rather than go through a mini lawsuit where there's no guarantee they're going to follow the law in making the decisions that govern the parties and then have to appeal a bad decision. Now, I'm not suggesting that all the arbitrators are bad. Some of them are really, really good, but there's no guarantee that that's who you'll end up with. And so I'd rather go the route of, if it's wrong, we can appeal it to a competent court, rather than we can appeal it to a judge who might have just as little knowledge as the arbitrator did of this subject matter. Okay. Now, fees and costs are generally awarded to the prevailing party in arbitration, but I have never seen an arbitrator actually award someone their actual attorney's fees and costs. It's always reduced. And when I say always, I mean literally none of the arbitrations I've done with a division have seen that the attorney's fees were the actual hourly rates or amount of work put into the case by the attorney. What does that mean for you? Depending on your retainer, I don't know of any attorneys in this arena that will say, if you don't get it awarded, we won't charge it. Meaning the association's out of pocket, which could have been avoided if you went straight to court after an offer for pre-suit mediation. So there is a procedure for arbitration. It takes a couple months to get through it, and then you got to file your lawsuit. For me, that delay is just not worth it. And that risk is just not worth it. Here's just a list that I found helpful of who can sue who. I don't think we need to go through it because you'll have the materials after. So let's move into self-help, which is another important topic. And don't worry, we're nearing the end of the materials here. I know we're running short on time, but like we said, we'll give a little bit of extra time after. So I mentioned self-help before. I didn't explain what it is or what the risk involved is. So let's do that now. Self-help is physically going onto someone's property and curing a violation, meaning there's weeds in the driveway. we're going to physically go out there and have a vendor spray for the weeds. They haven't mown their lawn in 6 months. We're going to physically have a vendor go out there and mow the lawn. Now, if this isn't allowed in your declaration, you're not allowed to do it. So it has to be in your deck. Usually in a condo, you're going to have the right of entry. You might not have the right of self-help. In an HOA, I'd say it's about 50-50 split, whether you have this or you don't. If it's not in your declaration, I will tell you, you probably should not add it unless it's the very basic violations that are being resolved. Here's why. For years and years, the advice that attorneys were giving is that it is inherently risky in Florida, especially, and especially in certain areas of Florida, to go onto someone's property. Okay. You've got a vendor physically entering onto someone's lot, entering into their unit, not entering into their residence, but let's say it's a roofing issue, going onto their roof. What are the chances that they get assaulted physically, verbally, shot? Okay. We've got this doctrine that says you can protect your residents in Florida. I'm not saying whether I'm in favor of or opposed to it, but it creates risk for any vendor that's going to go out. So for years and years, even though you had the right to do this, most declarations would say you may do it, not you must do it. And so we would say, well, it's too risky, don't do it. Go seek your injunction and you'll get your relief from the court. An injunction is basically a court order that says someone needs to start or stop doing something. Okay, so that's what we're asking for when we file your covenant enforcement lawsuit. It's a breach of contract, and we're asking for an injunction to force the owner to comply. Now, this was the case for years. About 12, 13 years ago, there was a case that came out, and frankly, I don't even remember the name of the case. But it basically says that a community association whose governing documents authorized the association to force place insurance coverage on a lot was required to go ahead and force place that insurance coverage because it was an adequate remedy at law to force place the coverage. The association in that case was not entitled to an injunction because one of the requirements of an injunction is that there is no adequate remedy at law. So there's a difference between equity, which is the court of fairness, essentially, and a court of law, which decides purely legal issues. So the self-help provision, there it dealt with insurance, was considered an adequate remedy at law. So attorneys continued even after that case saying, this is too risky. I'm not sending someone out on the property. And I don't think that this case applies when we're talking about a situation where it's physically entering someone's property rather than just buying insurance. Now, whether you can buy the insurance on someone else's property is a separate issue. I've heard arguments that you can't even do it if you wanted to. But getting back to what we're talking about today, now the Moriello case comes out in April of 2022. And it says, no, it's not limited to what we were talking about with insurance. If the association has the option of entering onto someone's lot and curing a violation, you have an adequate remedy at law and you need to pursue that before you can ask for an injunction. So our argument was, well, the Moriello case talks about going on and correcting some landscaping issues. It's weeds, it's mowing the lawn, it's edging. So those are the only issues we're going to deal with because we think there's still too much risk in dealing with any other issues. And then comes Meconico in 2023. And the court in that case says, the risk of the occupants of that residence verbally or physically attacking the vendor, which is exactly the argument everyone made, that is too speculative to justify not making the effort. Now, I think this is a ridiculous finding, but as of right now, it's the law in Florida. What does that mean for practical purposes? You need to at least send a notice that you're going to perform self-help if you've got that right, which your attorney should be telling you yay or nay, before you file your lawsuit seeking an injunction. At which stage you do this is up to the board. I've got some boards that I've kind of convinced, do it before you even send this to an attorney if you're going to do it. That way, you're paying your vendor to do the work and resolve the violation completely, rather than spending any attorney's fees or costs trying to force the owners to comply, which they've already ignored 2 or 3 notices. They're not going to comply. Okay. Another option that I see some communities taking is we failed at mediation or the owner ignored the mediation letter. We're going to send the self-help notice after we've done everything else we can possibly try before we file that lawsuit. Now, if you're not going to do it before the matter reaches an attorney, my preferred course of action at that point would be that you send out the self-help letter at the same time that you're sending the offer for pre-suit mediation. What you do in that instance, and this is a strategic move more than anything else, if the offer expires within that 20 days and there's no response, you just go do your self-help. Okay. You have the self-help letter expire shortly after your offer. If the owner responds, you send a second self-help letter and say, okay, we're going to do this work the day after mediation. What does that mean? If we don't settle at mediation, we're just going to resolve the issue and we're done. So it's hanging over the owner's head during that mediation conference, and sometimes it can push the owners into settling. Now, if the owner gets this letter and responds, you come onto my property and I will sue you, I will shoot you, I'll call the cops, you've probably done what you need to do, and you can go forward with your injunction, in my opinion. Okay, but this is something you have to at least send out the notice and make the effort before you file your lawsuit for an injunction, or you should, under Florida law, lose that lawsuit. So whenever we're handling a covenant enforcement matter, that's something we're really cognizant about, that, do you have the right for self-help or not? Did we notify the board that we need to send this letter beforehand? Moving forward, selective enforcement was what Courtney brought up earlier. Now we're getting into defenses. One is you had the right to perform self-help, you didn't do it. Okay, that's an absolute defense to an injunction claim. Selective enforcement, and I'm going to go through what these even are before we explain them. Selective enforcement is essentially you're forcing this person to cure, that's me, but you're ignoring these other 5 violations. Now, it's not just you're ignoring other violations. I've actually won cases on this particular subject. It's got to be a similar violation. And there is case law that says it's got to be similar in breadth as well. What do I mean by that? If you've got someone that's got one potted plant and potted plants aren't allowed, and you send them a violation notice and they say, well, that's selective enforcement. And then you've got someone else that's got 5 potted plants and they say that's selective enforcement. And you are ignoring someone with 20 potted plants, then the first 2 people were correct. It's selective enforcement, most likely, because you're ignoring the larger violations. But if you make the business decision to say, we don't think this is a major issue, we're not going to worry about it, great. There's your excuse. It's not selective enforcement. What I would suggest, if you're not sure if you want to enforce uniformly across the board, which is how you should be doing it, talk to your attorney about this risk. Okay. You've then got estoppel, which is very similar to selective enforcement. That basically is by the board's conduct in not enforcing against other people. I thought it was okay to go ahead and put this 3rd or 4th potted plant on my property. Another defense that could be raised is waiver. You knew that I was going to put it there. I put it there. You told me it was okay. And now you're coming after me later on. Okay. You've waived your right to pursue this violation. Latches is another one. Basically, this is the you snooze, you lose argument. It's by virtue of how long you waited to enforce this. I don't have the documents necessary anymore to defend myself to prove that you actually approved it. I actually had to deal with one of these cases, and it was one of the rare ones back in the day that I represented the unit owner. They had gotten approval to install something 7 years earlier. Association comes back 4 years later saying you can't have this. And they didn't have the documents anymore because the association waited so long. Okay. Now latches isn't based specifically on time. It is based on, because you waited so long, I reasonably got rid of the evidence that would have proven that I have a defense here. Then you've got the statute of limitations. If something's in place for 5 years, you can no longer enforce it. And then we've got unenforceable rules and provisions of the governing documents. Those are the ones that are basically discriminatory or are not reasonable. Rules also need to be supported by what's in the governing documents. So you can't just unilaterally decide, we've got no rule-making authority in the governing documents. We've got no restrictions on who can live here, but we're not going to allow certain people to do so. Okay, you can't just unilaterally decide without amending the documents to support those claims. Now, the defenses that get raised usually won't be raised until after you filed your lawsuit. unless someone is conscious enough to fight it up front. So you want to make sure you're doing this correctly because you've already spent a bunch of money by the time that lawsuit's filed and this person raises an affirmative defense. Okay. So moving on from defenses briefly, limitations on enforcement is the last substantive thing we have. So I know we're at 12:30. I'll go through this as quickly as possible, and then we will get into any Q&A that Courtney wasn't able to handle yet. Fair Housing and Americans with Disabilities Act. If you are you have someone asking to violate your rules because of a disability, because that violation will assist with the disability, that's something you might have to allow or be subject to a disability claim or discrimination claim. My recommendation, again, have a written policy that your attorney drafts in how you're going to deal with those types of requests. We do that on a fairly regular basis, and it helps the association to know what questions you can and can't ask, what you shouldn't ask, whether you can just reject the request because it's unreasonable, or if you need to go through a dialogue to make sure that you've asked the right questions to meaningfully consider the request. The over-the-air device rule is basically satellite dishes and things like that. You might need to allow them or at least control where they're located. But you might have to allow them, even though your governing documents say no, because there's a federal rule that the FTC has put out that says people can have satellite dishes of up to a certain size on their property. Solar collectors, same deal. There's a statute that says you have to allow solar panels, certain other things that are basically energy efficient. So if you are not sure if the item that you're talking about, usually we see this as solar panels or skylights. Those are both energy efficient devices, apparently, that there is case law about allowing them. That doesn't mean you have to allow someone to damage common elements to install them without a guarantee that they'll cover the cost of losing warranties, repairing those common elements, removing and replacing them if you need to, for example, replace the roofs in the community, etc. There are laws governing flags in particular and which ones you have to allow on certain days of the year. So you'll want to run that by your counsel rather than just refusing a request to install flags on an HOA lot or in a condo unit. Florida-friendly landscaping is something there are like 3 people in the state that actually understand, but just understand it's another thing that regardless of what's in your governing documents, you might need to allow. And then finally, we get into the more ridiculousness from the Florida legislature. In an HOA only, if something can't be seen from the frontage, an adjacent lot, an adjacent common area, or an adjacent golf course, and it's just something that's been installed, stored, or displayed on the lot, meaning you're shoving it there. Okay, it's not an ongoing issue that impacts other people. If it's an item that's placed on the lot or construction on the lot, and you can't see it from any of these locations that we mentioned, technically it's not enforceable under the statute. But remember the constitutionality argument that we talked about earlier. This one is blatantly unconstitutional, in my opinion. And this is the one that you're going to want to fight if you've got no Kaufman language in your governing documents. Again, this is HOA only. It's not condo or co-op. Same thing for HOA only, not condo or co-op. The law as of July 2024, July 1st, 2024 to be specific, states that trucks and commercial vehicles that don't qualify as a statutory commercial vehicle, which that's like 26,000 pounds and 3 axles or more. So these vehicles that are just a van that has a ladder that you qualified as a commercial vehicle, you can no longer tell the owners of those vehicles that they're not allowed to park on a driveway or in any other location that a vehicle can park under this statute. Again, constitutionality argument. You'll want to discuss that with your attorney. The other argument that I would make here is if you've got a situation where, for example, it's parked on a corner and it's a giant commercial vehicle, but it's not subject to the commercial vehicle statute, you can still restrict parking in that location because people can't see around the corner. You don't have to allow them to park in an unsafe manner. You just can't tell them they can't park in a certain location because it's a commercial vehicle. And then when it comes to denying an ARC request in in an HOA, you now need to specify why they were rejected, meaning you have to point to the specific restriction in your covenants or in your architectural criteria that says that the thing that they requested to do isn't allowed in the community. And then also look out, not statutory, but look out in your governing documents. If you've got that architectural procedure, look out for where it might say that if that's not denied within a certain amount of time, usually 30 or 45 days, it's automatically approved. Because at that point, you're just out of luck if they submitted a full application. And that is something you can deny a request based primarily on you didn't complete the full application. All right, we've done what we can. There is a lot more that I'd love to go through, but that would make this just as long as the condo board certification class, so we won't do that. We are through the material. I'm sure there's a ton of Q&A waiting for me. Again, if you need to reach me or you'd like to discuss with me, my email address is right here, as@kbrlegal.com. Just like GRS does LinkedIn, I personally post pretty much every day on LinkedIn. I'd say about 75% of what I post pertains to community association management. And so if that's something that interests you, which I presume it is since you're here, feel welcome to follow me. If you're someone that I actually know or that's in the management industry, feel welcome to connect as well. And I'm going to go ahead and stop sharing, and I will shut up for just a moment. Courtney, if you've got anything you need to add, go for it. Anyone that needs to go will still get the full credit for being here today. We're not going to require you to stick around forever while I go through the last few questions. And then, Courtney, whatever you have to add, go for it. And then I'll go through the Q&A and we can close out.
The only thing I have to add is thank you for the presentation. Very informative. I was very busy answering a lot of these questions. We had
Thank
a
you.
few. Some more came in. I did have it down, and then a bunch of people came on and added some things at the last minute, so I can help answer some. So again, if I answered your question, take what I say with a grain of salt. Some of them were pretty easy. Some of them were a little bit more detailed. Some of them were a little community specific. There were one or two that didn't really have anything to do with this topic today, but I still answered because they were easy. So with that being said, let's get into some of the questions. And like Alan said earlier, don't forget to fill out that evaluation. I saw you just put that in the chat again. Fill out that evaluation, especially if you're a CAM and you're wanting credit, you need to fill out that evaluation so you get the credit. So with that being said, let's go to a few of the questions. If you don't mind, can I read some off to you, Alan, or do you want to go through them?
Go for it.
Okay. So one question, because this was asked a couple times, and then I got myself confused. Let me find it. So a board has levied a fine, and then the compliance committee meets. They do the 14-day notice. All that is correct. The board or the committee confirms that fine. When does the fine actually start? Once it's confirmed by the committee, or does it start once the board voted at that noticed board meeting to fine?
So it's going to start once the board noticed the fine, because that's where the fine is levied by the board.
Yep.
It just doesn't actually go out to the owner unless and until that committee meeting occurs and it's actually approved.
So essentially, the board levies the fine, right? So for everybody listening, the board will levy that fine. That fine starts, that's day one. That's day one of the night of that meeting. So let's say you have $100. It's $100 fine every day. So essentially, because you have to send out a 14-day notice, by the time the committee meets and approves the fine, it could be $1,000.
Correct. And keep in mind also that if you have a provision in your governing documents that says there's no cap on fines, which is an amendment that I've worked on for some communities because they want to be able to fine forever until this is done, that can be, you could be up to $1,500, $1,600, $1,700 by the time that meeting actually takes place. Another thing that I didn't mention, but I want to make sure to get out before we close out, is an amendment that I recommend for every community association that doesn't already have it, that makes it easier to enforce your covenants from a financial perspective, is to make sure that your governing documents actually provide that every attorney's fee and every cost incurred in the enforcement process gets treated as an assessment against that lot or unit instead of just basically being treated as a cost of doing business. The other thing that should go in there, in my opinion, is that the attorney's fees and costs are owed by the responsible owner, regardless of whether or not you file your lawsuit. Because what I also see is that community associations are concerned, well, if I send out the notice through you, Alan, and after they get that first notice, they cure the violation, then that 250, 275, whatever the charge is, it's just eaten by the association. My response to that is yes, but you got your compliance, which was the goal of me sending the letter. But it's also easier if you combine these two potential amendments into one, and you make it so that you get your fees and costs back no matter what, whether there's a lawsuit filed or not. And I usually put it as once the violation is cured or we get a judgment without the fees and costs being awarded. Those are the two criteria where we get our fees and costs back, the association is paid in full, and if they're not, the association forecloses for that unpaid assessment. In other words, you're not leaving all of the members on the hook for what only one residence did.
Gotcha. Okay, another one that I thought was good, because I do see this happen as a property manager, where you have a board that kind of was lackadaisical. They didn't really do much with the rules and regulations. They didn't enforce anything. And then a new board comes in and they want to start enforcing things. So how can they start doing that?
So they start with what's called a chattel shipping letter. It's basically a letter that goes out to the entire community and says, hey, there's a new sheriff in town. There are two different ways that that letter can be worded. There's the way that most law firms word it, and then there's the way that we do it. So the way most law firms do it is, starting now, we're going to enforce everything across the board. That's the way that the case specifically outlines it. The other way to do it, which I think is better, which is why we do it this way, is you say, even if there's an ongoing violation that's been in place for 2 years already, we're giving you 30 days to register that with us as an existing violation. Anything we find after that 30 days that's not registered with the association, we're going to presume as a new violation, and we're going to go after it that way. So you're not grandfathering every single violation that the old board ignored. You're basically saying, listen, if you take the affirmative step of sending us this form completed, then you're grandfathered. Otherwise, you're out of luck and we're going after you.
Gotcha.
So those are the two options, but that chattel shipping letter, and that comes from a case called chattel shipping, but that type of new sheriff in town letter is the way that I would handle that issue.
That makes sense to me. That totally makes sense. Okay, a few people have the same question about the self-help. You talked about the self-help, that the association may have the right to correct the violation. So the question is, how do they get, if there's a cost associated with that, how would the association recover the cost?
So usually the declaration will actually say that if you perform the self-help, the cost is treated as an assessment against that lot or unit. If your declaration says that, you're golden. You just add it onto the ledger. Now, some of them won't be clear enough, and you'll have to actually have a meeting just like you were levying a special assessment, which we say it goes out with 14 days notice, but that 14-day notice only needs to go to the actual owner who's being assessed.
Yes.
And so what you would do in that instance is you would have, finish up the work and then levy a single assessment for everything that the board had to do against that particular owner. And what I usually suggest is, let's say in a given month, you've done this for 15 different owners, just have a motion by the board that any special, any costs incurred in pursuing self-help this month are to be treated as a special assessment against the pertinent lot. And then you've got your list separately of which lots you're actually talking about. And all of those individual lots will get the 14-day notice. Other than that, you can just post the notice and you don't need to give 14 days notice to everyone in the community. And then if that's not in there, you can amend your declaration to say that.
Yeah. I had a community that I managed that we had to do that in a scenario. Someone's pool got really, really gross. and you could see
That
it.
happens.
And we felt like it was a health hazard. And luckily we didn't actually need to do anything, but we, got the quotes to do the work that was needed. And we sent the letter to that homeowner saying, we're going to come and we're going to fix the pool. It's going to be this much money. We're going to have it noticed at this board meeting and discuss it at a board meeting that we're going to take these precautions. And before we had to have the board meeting, the person went and cleaned their pool and took care of the violation. So hopefully that's what most of you guys have to do, and you don't have to do the actual work, but you heard what Alan said about recovering the cost. A few more. A lot of people have had questions about some ARC stuff. Hold on, let me just see. There's one. Is it only that the ARC denial points to the docs and should be published guidelines, but it doesn't have to be specific like color, but the denial is color must come from the color palette, right? Sorry. That, I think what they're trying to say is, so there
So
is
it
a
doesn't
new,
have to be directly this provision of the declaration. It has to, if you are saying it's a provision of the ARC guidelines or it doesn't match the color palette that was provided, yeah, you can just say this provision of the guidelines points to the color palette. You didn't use the colors that are included in the palette, and that's the end of it.
gotcha.
If you're talking about, this is something that's explicitly prohibited in the guidelines, you just point to the provision of the guidelines. But if it's the color palette, you don't have to provide a copy of the color palette or the color wheel along with the denial. You just say these colors are not included in the color palette that you're asking for.
Okay. And then two more quick questions and then we'll be done. I lost my question, sorry. Where was it? Oh, how long after an owner has been fined for non-compliance can a new violation be open for the same offense if not remedied?
That's part of the problem, is that you generally can't if it's still an ongoing continuation of the same offense, which is why I say the fines are a waste. You get one shot at that. So if your governing documents say it's up to $1,000, it's up to $1,000, and that's the only thing you're going to get out of fining. You're not going to start over unless you see that it was cured for 5 minutes and then they went in violation again.
Gotcha. All right. That was a good one. And then I think that's it. I think
Okay.
the rest of them are just like thank yous and some things that aren't covered, aren't on today's topic.
So one thing that I do see that if you don't mind, I'll just handle very quickly. We
Yeah,
didn't talk about parking issues other than trucks and commercial vehicles. I did want to be clear. This question talks about parking on the grass, and I'm sorry that I'm not addressing it directly. Anyone that didn't get answered is welcome to email me. But as to parking, if your association doesn't own your roads, you cannot enforce parking on those roads. Meaning, if the city or the county actually owns the roads in your community, you can't enforce parking on the roads. You can call the city or county to enforce it, but that's an issue that probably should be in the slides, frankly, but it's such an outside issue, even though it's related to enforcement, that it's hard to figure out where to put it. But I do want to make sure to mention that that's something that comes up frequently, that, people are upset that you're not enforcing your parking restrictions and are not realizing that those restrictions don't apply to roads that the association doesn't own.
perfect. I forgot one thing I did. I
Okay.
promised somebody I would ask your question and I answered it, so I forgot, but I wrote it down. Can covenants be enforced if they are not recorded with the county?
Covenants, no. Rules and regulations, yes. Now, that doesn't mean you shouldn't record those rules and regulations, because then everyone is supposed to be on notice of what's in them, not just the people that live in the community and have the right to get copies of those rules. So there's a benefit to having them recorded, but it's not required. The other thing to keep in mind is once you record them, if you want to make any changes, you got to record the changes as well. So it's a plus and minus game, but my recommendation, if you're not sure what to do, get them recorded, because then there's no question that the people were at least on what's called constructive notice of what's in those rules and regulations. So if someone buys in, those rules aren't recorded and you didn't provide them a copy, they maybe have the argument, I didn't know that that rule applied. That's not going to be an excuse, but you completely avoid, pardon me, you completely avoid the argument if you get those documents recorded first.
Perfect. All right, so with that being said, we'll end today's webinar. Again, thank you, Alan. And then for everybody, because there was a few Q&As asking for the link is in the chat. I sent it over to some of the people that were asking in the Q&A, but there is a separate area that's chat, and there should only be 2 comments, I think 2 or 3 comments in there, and they're all from Alan, his email, and that evaluation form. And then are the slides going to be provided in the once they go to the evaluation form, can they get the slides there?
Yeah. So once the evaluation is completed, they'll get the link with all of the information, your contact information, my contact information, the slides, etc.
Perfect. Again, thank you everyone for attending. There's, like I said earlier in the introduction, Kaye Bender Rembaum does a great job providing these courses all the time. There's at least 3 or 4 a week. Go to their website, kbrlegal.com. You'll see an area called KBR Calendar. That's where you can see a calendar of the events. You'll click on them. You can see the registration link to register and attend future events. Again, if we didn't get to your questions, we apologize. Alan was very kind and has listed his email. You can always ask him. You can ask me too. My email is cbuchan@grsmgt.com. And I hope you all have a great rest of your day. And thank you. See you soon.
Thanks again, Courtney, and to GRS in general for having us. And thanks everyone for coming, and to over 100 of you for sticking around this long.
Bye. Have a good one. Thanks, Alan.
Thanks, everyone. Have a good one.